A very warm welcome from the Centre for International Law at the National University of Singapore to this webinar, which is in conjunction with the Singapore Convention Week. It's an honour to be able to participate. It's a seminar that's titled How Investment Treaties Address Mediation and Conciliation, Need for Improvement. The genesis of this topic resulted from an article that I wrote. My name is Romesh Weeramantry. I'm a global fellow at CIL. I co-authored this article with Brian Chang and Jared Chow, and it's published in the ICSID review. It really deals with looking at investment treaties from an empirical perspective. We looked at over 3,000 investment treaties to conduct this the study, which is essentially outlined in the article. So if you do have any questions about what we say about the article today, I'd urge you to go back to the article itself. There's a link in the material that's been sent to you to that article and it's been published in the ICSID review. And now just a quick outline of the format. I'll present the article to you and its contents, and then I'll hand over to Professor Jansen Calamita at the Centre for International Law, and he'll be moderating this with three very able and experienced speakers. And the speakers will speak from different perspectives about this need for improvement in conciliation and mediation provisions in investment treaties. You'll hear from a mediator's perspective, you'll hear from an institutional perspective, and you'll hear from a treaty negotiator's perspective. But I'll leave Jansen to introduce the speakers to you, but they are very well experienced, and I'm sure that what they have to say will be illuminating. Now, I'm going to share my slides, and if I could just hope that I will be able to do this. I'm going to start the slide. So please let me know if the slides aren't on the screen. Can you see the slides there? Great. Okay, so the title of the article is called Conciliation and Mediation in ISDS Provisions, a Quantitative and Qualitative Analysis. As I said, I've co-authored this and it's published in the ICSID review. What I'll take you through very quickly, and as I said, please consult the article if if there are details you need to sort of connect with what I've said. I'm going through very quickly a lot of material here, so please feel free to revisit the article. Now, I'll basically summarize what we found out, and essentially that's what's in these treaties, what's in treaties that concern conciliation and mediation, particularly in the investment sort of treaty arbitration provisions. So we'll look at that. Then we'll look very quickly at, are they being used? Now, a bit of a spoiler for you, they're not being used that much, these provisions. So the third point that we'd like to talk about is why aren't they being used? And finally, I'll just sort of highlight some of the main proposals we made for this sort of lack of use to be changed. So what's in the treaties? Just before I talk about this, just a note on how we conducted the examination. First of all, we started with a keyword search, and we looked at as many investment treaties as we could. Now, just note the date. This was up till we started the research in April 2021. So that's we made the cutoff date then. And so what we did was we searched through 3,815 investment treaties. And we did this keyword search, and what we found was, astonishingly, 70% of treaties do not refer to conciliation or mediation in ISDS provisions. So that was in 2,674 treaties. The flip side is that 1,141 of these treaties did refer to conciliation and mediation. And what we did was we took that group and we looked at each of those treaties and we examined the content of those provisions, and then we categorized them. What we did find was that 1,125 of these treaties referred to conciliation. We also found 53 of these treaties referred to mediation. Now, that adds up to more than 1,141 treaties, because there was some treaties that referred to both. So we counted them twice. So what we found was that for conciliation provisions, right, in those ISDS clauses in investment treaties, you had a very good start. So it started in the early 70s, and obviously it's gone through right through to the current years. But what we found was that there was a gradual decrease, and you'll see that in the red line. Now, what's very interesting here is that, I'd say, the high point in these provisions was around about 1980s, early 1980s, when 60% of treaties that were signed for that year or those years, 60% of them referred to conciliation. But as you see from that red graph, there's a decline, and that decline represents the decrease in the references to conciliation in investment treaties. And very interestingly, the converse happened in our investigation about mediation provisions. Now, that's represented in this graph where you have got the blue line. Here you'll see an increase in the references to mediation. Again, we use the same metric. We say, where basically we analyze this from the percentage of treaties signed per year. What percentage actually mention mediation? But what you find interesting here is that, remember, there are 2 points that I'd like to mention. First is the introduction of mediation provisions, that the actual word mediation only found its way into investment treaties in 2004. And you saw the earlier graph that showed conciliation provisions started way back even before 1970. So that's the first point. The second point is there is an increase, which is a good sign. The problem, I think, with this increase is we're not looking at 60% of investment treaties signed per year that have mediation. We're looking at less than 20% of investment treaties that are signed, I would say in about 2018, that's the high point. Less than 20% had the word mediation or referred to mediation in the ISDS provision. Now, in terms of the content of these references to conciliation or mediation, we'll start with conciliation first. So by far the most frequent reference to conciliation was that what we call category 1. It's called, and we called it a conciliation or arbitration type of provision. Now, I'll explain this. Essentially, this is a provision where states provide advance consent to either conciliation or arbitration. Now, that happened. We found 703 treaties with that sort of provision. So it's advance consent to conciliation or arbitration. I'll speak a bit more about the issues relating to this type of provision, but that was advance consent. So, and there are many more variations of these types of conciliation provisions, but most of them provide advance consent. But you'll see in category 7, we have a provision that requires parties to agree to conciliation. So that obviously is not advance consent, but if you compare it to the category 1 type of claims, there were far less of these types of provisions in the treaties. We found 123 of them, but that required consent. Now, in comparison, when we looked at mediation provisions and their content, we found a bit of a reverse. We found that the more sort of frequently used type of provisions required parties to agree. So there was a lack of that sort of advance consent. So that's the category 3 provision that I've marked there. Whereas category 4, right, was what we classified as pre-arbitration mediation provision, but that was essentially, it wasn't, there wasn't the sort of the consent there again. And then in category 6, I just wanted to draw your attention to, there's a specific type of provision, only in 5 though, that requires mandatory mediation before you go to arbitration. So it's a precondition. But there are lots of different categories. We've found 11 different categories for conciliation, 7 different categories for mediation. As I said, please consult the article for the details if you're interested in and looking at these categories in more detail. Now, that's the content and the numbers covered. Now, as I foreshadowed, are they being used? The answer is very rarely. And you'll see, and these are just statistics from the ICSID 2022 caseload statistics. Over 90% easily of cases go to arbitration, but less than one, or I would say 1.5% go to conciliation. So there's a stark contrast. So the next question would be, well, why is this, what explains this low rate of use? One obvious explanation is that, well, most treaties, as I said, 70% of these treaties don't refer to conciliation or mediation. That could be a reason. The other reason, and this gets back to that conciliation provision I mentioned. It says basically, essentially, the state will consent to the submission of a dispute by an investor to conciliation or arbitration. So they're the specific words used. Now, one interpretation of this could be that this is a fork in the road. If you go to conciliation, then that will preclude arbitration because of the or used in that context. In the article, we give reasons why that may not, hold, and there are arguments to say that essentially you can go to both. So that's again covered in the article. But potentially, if you're representing an investor, would you really want to go to conciliation if that precluded arbitration, given the language used in the treaty? So again, that could be a reason for this lack of use. Other reasons, and there are more, the lack of familiarity by government officials about the mediation process. Do they really know how effective it is, or do they have confidence in the process? And the other issue is obstacles, legal obstacles. But I hope that we can talk about that later in this session. Now, finally, what can be done to change this lack of use of mediation or conciliation in investment treaties? Well, obviously, first of all, increase the use of the actual these methods, these modes of dispute resolution in the treaty provisions themselves. And secondly, improve their quality. Now, I'm giving 5 reasons, and these are sort of the main highlight reasons. One is provide advanced consent to conciliation up front, conciliation or mediation. As most of you would know, once a dispute arises and you need agreement, that could very often lead to disagreement about whether conciliation or mediation should take place. So if you provide advanced consent in the treaty itself, that may promote more of this mode of dispute resolution taking place. Secondly, maybe clarify the choice of conciliation and mediation does not trigger a fork in the road, especially in those conciliation or arbitration type of provisions. Thirdly, essentially in the treaty provisions, encourage conciliation or mediation during the arbitration consultation phase. That's the sort of the cooling off period before you can commence arbitration. potentially consider making it mandatory as a condition prior to arbitration. But as we found in our study, there aren't many treaties that have this provision. There's less than 10 for conciliation, there's less than 10 for mediation provisions in existence. The fourth recommendation was provide guidance on how the mediation process will work and operate. What steps are required, what are the expectations that you will have, what are the efficiencies that mediation has over arbitration. Bring these to the fore in concrete terms. How much time will be saved potentially, how much cost will be saved, how many, what sort of phases, what sort of procedures will you have to go through if you engage in mediation or conciliation. And finally, my last point is potentially think about empowering a tribunal to propose to the parties in a non-binding manner that certain issues may benefit from a separate conciliation or a mediation process. Now, the issue behind this is sometimes arbitrators think, well, we may be accused of prejudging issues if we suggest that this should be settled. But if you have that embedded in a treaty, and if you give the tribunal power to do that, then potentially there's less risk of that argument, and there's less risk that arbitrators will be concerned about this issue. So that's a very, very quick run through of the article and its highlight points. And now I'll hand you over to Jansen, and hopefully we can speak a bit more about the content throughout this seminar. Thank you.
Thank you so much, Romesh. Thank you very much for your presentation, which I think really draws out some of the most salient and thought-provoking aspects of your findings with respect to current treaty practice, and raises interesting questions for us about future treaty practice, but also beyond treaty practice, dealing with other aspects of decision-making by states and investors, whether or not to use conciliation or mediation, which I think we will get to some of these issues in the presentations that we have coming up next. And I will give brief introductions so as not to take time from those presentations and from our discussion at the end. But we will begin with a presentation by Anna Holloway, offering an institutional perspective, in this case, a perspective from ICSID. Anna is legal counsel at ICSID and has worked extensively on mediation issues at ICSID. Anna's presentation will be followed by Heng, who is senior state counsel at the Attorney General's Chambers here in Singapore, and is the head of Singapore delegation to UNCITRAL Working Group 3, addressing the reform of investor-state dispute settlement, including alternatives to arbitration, such as mediation and conciliation. And then finally, we will hear a mediator's perspective from Wolf von Kumberg. Wolf was for many years in-house counsel to Northrop Grumman, working on the resolution of disputes and avoidance of disputes. He is now an independent mediator, and among other things, Wolf has been deeply involved in developing and promoting mediation as a tool for resolving not only commercial disputes, but investor-state disputes as well. So it's a great pleasure to have all of you, and without further ado, let me turn things over to you, Anna, for your remarks.
Thank you very much. And I would like to start by saying thank you, Romesh, and to you and your colleagues for your excellent article, and also for your concise presentation of your findings today. As Jansen noted, I've been asked to speak to this topic from an institutional perspective. But before I turn to that, I do want to convey my personal view of the importance of empirical analysis in legal scholarship. It is very hard to know how to move forward without first knowing where you in fact are. And it is scholarship like this that provides an excellent resource, in this context in particular, for institutions and particularly for treaty drafters. And I'll ask if we can have the next slide, please. Thank you. So actually at ICSID, we have also sought to contribute to the mission that Romesh is advancing with our own survey. This is not quantitative, but it looks at the provisions of treaties and model clauses that provide for amicable dispute resolution generally and for mediation specifically. And I thought today, in light of Romesh's presentation, that it could be helpful to speak to our analysis also a little. So rather than an empirical analysis that quantifies the prevalence of different categories of provisions, we focused more qualitatively on first the specific ways in which mediation and other forms of dispute resolution, amicable dispute resolution, have been included in disputes clauses. And then beyond that, the extent to which clauses that include amicable dispute resolution mechanisms, such as mediation, seek to regulate the procedure to be followed when disputing parties actually resort to that mechanism. And our objectives here were threefold. First, we wanted to ensure that we as an institution have a clear understanding of the extent to which mediation is provided for in existing treaties, as we continue to progress our work in facilitating mediation of investor-state disputes. We also wanted to provide, and this goes to the point that Romesh made about how to advance things, some additional resources to those who may be seeking to draft treaty provisions that provide for mediation of investor-state disputes. We reasoned that a summary of commonly adopted approaches that treaty drafters have used in the past could in fact be useful. And I will emphasize here that in light of that objective, our analysis was limited not just to looking only at treaties providing for mediation, but also the ways in which treaties that provided for other amicable dispute resolution mechanisms have incorporated those obligations into their clauses. And we reasoned in this regard that the drafting mechanism utilized for other contexts could readily be utilized in the context of providing for mediation in some manner. And thirdly, our research was provided to the UNCTAD Secretariat as part of ICSID's activities to support the reform discussion of Working Group 3. So despite different methodologies and emphases, there's significant crossover in, for example, the types of classifications of provisions that we saw to those that Romesh has presented today, although we have looked at them in a sort of a higher level and have a fewer categories than Romesh has presented. But since there is so much crossover there, I wanted to talk just a little bit about the question of how the clauses have sought to regulate the process of these procedures and of mediation in particular. We found that the substantial majority of investment treaties and model clauses that expressly provide for amicable dispute resolution, including through mediation, do not really regulate the procedure or the procedural steps of that process. To the extent they do, they typically provide only minimal guidance, mainly relating to the commencement of the process and how the process interacts with other proceedings relating to the same dispute. So some disputes clauses will have provisions regulating the filing of a written notice of dispute to initiate the procedure, such as mediation. And there are differing approaches in treaties as to what is required for this written notice, in terms of the nature of the notice, the detail that is required, etc. Some clauses regulate the provision of a response to or the consideration of a request for mediation or another ADR mechanism by the state. A growing number of treaties specify the agency to which requests for amicable dispute resolution are to be directed. Some disputes clauses address concepts of without prejudice privilege. And some treaties have clauses that address the relationship between the mediation or the other ADR mechanism and other proceedings. For example, when there's a concurrent arbitration that is pending when an agreement to mediate is reached. And while a very small number of treaties do regulate the mediation procedure in detail, based on our analysis, this is very uncommon. And I believe that is a finding that Romesh and his colleagues shared too. So based on this analysis, we have gathered some general thoughts that emerged with respect to what states might consider when seeking to include mediation in their disputes clauses, when they should make mediation available within the investment conflict continuum. Should it be available throughout or in concurrence with other proceedings? They should maybe consider whether to seek to mandate it, and that's a suggestion that Romesh made. Either mandate it for both parties at the state's election, mandate it at the investors' election, or have the requirement to participate exist only where there is express agreement. If that last situation, whether the treaty should include any language to place the finger on the scale of encouraging mediation, even if it does not go so far as to mandate it. Drafters may consider the appropriate duration of an amicable dispute settlement period to appropriately allow for a mediation or a similar mechanism to take place. And lastly, they can consider what, if any, regulation could be included in the process. Should they include written notice requirements, and how should they regulate these? Should they impose requirements to have the state respond to a request? Should they include designated agency provisions? And if they do, how should they try and make sure that these remain up to date as changes in government take place? And lastly, should there be other regulation? And in this regard, we would suggest it's worthy of considering whether to regulate the procedure directly in the treaty, or whether it is perhaps preferable to simply stipulate that a set of mediation rules will apply to govern mediation arising under the specific clause, just in the way that is often done with respect to arbitration. Rules such as the ICSID mediation rules already govern all aspects of procedure and provide a mechanism for additional parts of procedure to be agreed. So incorporating rules like these can avoid procedural lacunae. And since rules can be updated over time, they avoid, incorporating them avoids a treaty clause becoming a little time stuck. Can we move to our next slide, please? So the third point I'd like to focus on is the observation from Romesh that provisions calling for mediation in one manner or the other are on the increase, and that there is potential for significant increase still. And I'd like to talk about what ICSID has done in this regard. The most obvious point here is that we have now finalized and had entered into force this year our first set of mediation rules. Next slide, please. The impetus for this is what we observed some years back now as a trend to consider mediation as a tool to resolve investment disputes. Of course, this trend was seen in the increase in mediation references in treaties, which we've heard about earlier today. But there were other events as well. The 2016 Guide on Mediation and Investment Mediation prepared by the Energy Charter Conference. There, of course, is the multilateral work on the Singapore Convention, which is why we gathered here today. And we observed as well within our statistics, something that really suggested mediation was a potentially advantageous tool, namely that around 30 to 40% of arbitrations at ICSID settle or are otherwise discontinued before an award is rendered. Given these factors, it really seemed clear to us that the promulgation of mediation rules that parties could elect to avail themselves of lay squarely within the wheelhouse of ICSID's role in assisting its member states with the settlement of investment disputes. Next slide, please. Excuse me. So ICSID's mediation rules are intended to complement the treaties we've been discussing, and also to complement ICSID's other dispute settlement offerings, most notably arbitration, and to provide additional process options for parties. We intend for them to provide a flexible mediation process and to assist parties with a timely and cost-effective resolution of their disputes. Importantly, the mediation rules allow for tailor-made solutions to disputes, more so than arbitration, which most typically involves military awards only. And lastly, rules were intended to align with the formal requirements of the Singapore Convention. Excuse me. Next slide, please. So the mediation process envisioned under our rules is shown on the screen, and I won't go through it for interest of time, but I just wanted to emphasize 3 points. First, the rules are very broad in terms of who may come to ICSID to have mediation administered, providing, of course, the parties agree. Specifically, the Secretariat is authorized to administer any mediation proceeding, providing that it relates to an investment and that it involves a state or a regional economic integration organization, such as the EU. Second, the rules provide a mechanism for a party to seek agreement of the other disputing party, which is a request that our member states made, and we think could be advantageous to helping parties reach agreement to mediation. And third, the specific details of how the mediation is to proceed left to the agreement of the parties as facilitated by the mediator. So they make mediation under these rules very flexible. Next slide, please. So the final point I'd like to make briefly is that ICSID, along with other institutions, is undertaking significant work to help raise awareness and enhance capacity with respect to the mediation of investment disputes. And that's a point I think Romesh had commented on as being important. So in particular, we have an extensive webinar series and a series of background papers, including the overview of treaty provisions that I mentioned earlier. These are all available on our website, and there are links in this slide if you want to access them after this event. Excuse me. And in particular, we have a dedicated website section and newsletters, and we've been running a number of training courses in an attempt to enhance capacity. Next slide, please. In addition, we've been offering or participating significantly in terms of inter-organizational cooperation in this sphere. So we have provided support to Answer Trial Secretariat, and we've organised joint events with them. We've provided support to IFC, part of the World Bank Group, on mediation skills training for government officials. And we've undertaken a number of cooperation projects, which I set out there on the slide, and I won't dwell on for interest of time. So that is all that I wanted to share, although I'm happy to answer questions once all our speakers have spoken. Thank you.
Thank you very much, Anna, and thank you for keeping to time. And I should have apologized in advance to all speakers that given the time that we have, our speakers are limited in what they can say in their prepared remarks to about 10 minutes. So please don't think anybody's being cursory. They're just sticking within the framework of our current webinar. That brings us then to Heng Ong. So Chin, let me pass things over to you.
Thank you very much, Jansen, and thank you also to Romesh and Anna for your very useful contributions at the beginning. Romesh, I've had a chance to read the paper, the article that you've written, and I think it is it would certainly be useful for our participants in the audience to also go through it in detail, because it really helps to color the discussions that we're having today. So I'm supposed to speak from a treaty negotiator's perspective. So let me start off by first recalling and acknowledging the excellent cutting edge and synergistic work that has been done by various institutions to enable and promote the mediation ecosystem. Because all of this groundwork has helped to make investor-state mediation a viable, understandable, and meaningful alternative to ISDS arbitration. In particular, and I say this not just because Anna is on our panel today, but because this is really reflective of the work that has been done by her institution. Here, we really should tip our hats off to the ICSID Secretariat for the Herculean work in putting together, a whole suite of rule amendments, of which we have the brand new 2022 ICSID mediation rules as a part. And Anna has spoken about that during her session, so I won't say very much more about that. Besides the work that has been done by ICSID, I should also acknowledge the work done by various other organizations, including the International Bar Association, as well as capacity building initiatives and other tools that have been developed around the world. And I believe that Wolf will be covering possibly some of these in his segment. Finally, my opening comments would not be complete without also briefly acknowledging at this stage the ongoing work at UNCITRAL on ISDS reforms, including its work on developing mediation, and I will return to that towards the end of my comments today. Next, I would like to highlight the advent of the UN Convention on International Settlement Agreements resulting from mediation, which all of us call the Singapore Convention on Mediation for short. That is a key new development in this space. So personally, I am excited and hopeful that it lays a solid foundation at a structural level for mediation and mediated outcomes to really come into their own. In the same way that the New York Convention served essentially as a game changer for international commercial arbitration. So the Singapore Convention entered into force just 2 years ago, on the 12th of September 2020. So we're almost at the 2-year mark. And it is, I believe, in force today for 9 states. And come November, it will enter into force for a 10th country. And I believe that would be Kazakhstan, because they filed they lodged their instrument of ratification in May this year, and the 6-month mark will bring us to November. So under the Singapore Convention, international mediated settlement agreements in the investor state context can also be enforced or invoked in states that are parties to the convention, so long as that state did not make a reservation under Article 8 of the convention. The Singapore Convention allows investor state mediation to meaningfully exist on a standalone basis. And I say standalone because I want to draw the distinction between this and, say, mediated settlements that are recorded as consent awards in a med-arb or arb-med-arb configuration, because in the past, mediation or consent awards would have tended to be recorded as an arbitral award in order to get around the fears about the non-enforceability of a mediated outcome. But the Singapore Mediation Convention is intended to address that issue, amongst others. Now in Singapore, we have implemented the Singapore Convention by way of our Singapore Convention on Mediation Act of 2020. Needless to say, the convention in the last 3 years, I think, has enjoyed a relatively strong start with 55 signatories today. And to date, it is in force for 9, as I mentioned earlier. So it will be very interesting to see what happens on this front when the convention enters into force for more signatories in the months and years ahead. So at this point, I think it goes without saying that Singapore strongly supports the use of mediation as a complementary means for the settlement of investment disputes. Mediation is an effective, efficient, and affordable form of dispute resolution. It has the added advantage of helping to preserve the relationship between the disputing parties by resolving disputes in a manner that suits the interests of both parties. Mediation can help address concerns about the cost and duration of ISDS proceedings, and compared to arbitration or adjudication, mediation permits for meaningful prospects of reaching what I call non-zero-sum outcomes, or win-win outcomes, as some people would like to call. I will say no more on this point because I believe that Wolf will cover the unique advantages of mediation as a tool for dispute resolution later on in his segment. Now, since I'm speaking from a treaty negotiator's perspective, I should briefly touch upon Singapore's recent experiences and treaty practice. In this regard, we support the inclusion of mediation as an option in addition to the usual ISDS arbitration. As Romesh's study has revealed, several, but certainly not all, of Singapore's own older generation BITs make reference, maybe not to mediation, but at least to conciliation. In this context, I would recall that the reference to conciliation actually rides upon the ICSID conciliation procedure that's contained in Chapter 3 of the ICSID Convention and has been around for decades already. So our old treaty practice, as you can see on the screen, is reflective of that, and you have formulations like, you know, if the dispute cannot be resolved via negotiations or consultation, then the investor may submit the dispute for conciliation or arbitration by ICSID, or a more meaty formulation includes a reference to conciliation or mediation within the within a clause that talks about good officers, third-party procedures, etc. And so you see 2 examples of our treaty practice in what I call the older generation treaties. Now, in our more recent treaties, we have begun to explicitly articulate and provide for mediation as a possible option for dispute resolution, standing side by side with arbitration. So in some treaties, as shown on screen, sorry, actually this is the second formulation on the screen here. Disputing parties are allowed to engage in mediation at any time, even after the tribunal, an arbitral tribunal has been established, and there is no specific mediation mechanism prescribed, but there is at least a reference to mediation, and there are treaties that contain such language, such as the CPTPP. Next, we have mediation being referred to in treaties such as the Indonesia-Singapore BIT, and I thought that was an interesting example for me to raise, because I understand that there are actually a lot of friends amongst our audience tuning in from Indonesia for this session. So this is the treaty that Singapore has with Indonesia, and there is actually a self-standing and dedicated article on mediation. And in this regard, you will see that there is actually an encouragement for a party when requested with mediation. There is actually an encouragement for that party to give sympathetic consideration to the request for mediation, whilst still acknowledging that mediation is a voluntary process and without prejudice to the legal position of either disputing party. If I can then move on to another example of mediation clauses in our recent treaties, you have an example here on the screen, which is the EU-Singapore Investment Protection Agreement that goes somewhat further, because we refer to mediation as a standalone mechanism, but this treaty also sets out relatively comprehensive and detailed procedural rules on mediation, and these are set out in detailed terms. On this page, you see language that's similar to what was reproduced in the Singapore-Indonesia BIT. But if I go on to the next page, you see that there is actually an entire annex that is dedicated to mediation. And amongst other things, again, you see that there is a clear encouragement that if there is a request for mediation, the party that is requested shall give sympathetic consideration to the request. So there are different approaches. Some approaches may be more comprehensive or more effective than others, but in Singapore's view, there is no single best approach. If I can round up my comments by circling back to what I said, something I said at the beginning, which is UNCITRAL Working Group 3. It's actually interesting that within the next 2 weeks, starting next Monday, in fact, Working Group 3 of UNCITRAL will be discussing a couple of working papers that contain draft model provisions on mediation. And so against this backdrop, today's panel is actually very appropriate, apposite and relevant, because it foreshadows the discussions that will take place in about 2 weeks' time in Vienna. And I certainly hope that those discussions at UNCITRAL present, exciting new opportunities to develop this space further. The Singapore delegation, of which I am a part, will certainly take a constructive and facilitative approach to advancing these discussions. So in conclusion, if I can circle back to the question posed in our panel, which is there room for improvement? Well, I would say that there is always room for improvement. But I hope that I have demonstrated how the various developments that I've shared earlier in the last 10 minutes, both undertaken by states as well as institutions, as well as both on a bilateral and multilateral basis, I hope that I've demonstrated how these have represented a very strong trend, and that in the years ahead, we begin to see mediation really come into its own, including in the investment dispute settlement universe. And with that, I thank you very much for your attention.
Thank you very much, Chin, for those remarks. Looking forward to the discussion in Vienna next week. Let me pass things along to Wolf for his perspective as a mediator and as someone who works intimately in the field on particular disputes. Wolf, please go ahead.
Thank you very much. And I'd like to thank everyone actually for their contribution today, because I think it sheds a lot of light on what has been happening with mediation in ISDS, certainly over the last decade. And I think we can only really talk about this over the last decade as Romesh's excellent article demonstrates to us. Conciliation is something that has been around in the ISDS world a long time, and that's because ICSID actually has conciliation rules, which have been part of the ICSID process together with arbitration. And I've been told actually when those rules were first formulated, ICSID really believed that conciliation would be the primary tool that investors and states would utilize to resolve their disputes. For whatever reason, and that might be another interesting study, arbitration actually became the preferred method of dispute resolution in ISDS. And the conciliation rules, as Anna could well tell us statistically, have not been used very frequently at all over the years. And so it's interesting also in Romesh's statistical review that mediation, utilizing the modern term of mediation, has been really only seen to be used since around 2004. And so I think as we see the development of modern treaties, the inclusion of mediation, as again the statistics demonstrate, is on the increase, because there's now a greater awareness and understanding that mediation in the context that we're using it here is different than conciliation. And that conciliation in the old treaties is not mediation as we understand it. And so part of the issue here, and this is really, I think, again, what Romesh has brought out, is really a lack of knowledge and perhaps of capacity with respect to mediation. And again, I think we really have to commend ICSID here on recognizing this distinction and coming up with their set of mediation rules now in conjunction with the conciliation rules and the arbitration rules, and distinctly showing, I think, both investors and states that mediation is a different tool that can be used in the process. And so I think part of what we have to do as the ISDS community, all of us, is really develop understanding and knowledge and capacity for the use of mediation. And that's really what has been happening over the last decade. In fact, as we see the use of mediation starting to creep into treaties in 2004, 2005, there was also an effort, and we have to recognize this, by the IBA, because the IBA were the first institution to actually come up with mediation rules. They came back up with mediation rules back in 2011 and promulgated those. And that was really, I would say, the start of people starting to look at mediation as a potential tool in ISDS. Over the years, and I've worked closely with ICSID and the ECT, both of those institutions, together with CEDAR, have really been instrumental in starting to incorporate mediation into the investment dispute arena. And I really commend all of those institutions for the effort over the last years. As has already been alluded to, so we've got mediation rules, which are important in the context of treaties being a roadmap towards the use of mediation, but the rules actually providing the meat as to how the mediation process can be utilized within those investment treaties. And as I say, they're the older IBA rules, and we now have the ICSID mediation rules. And I think that's really an important catalyst to the use of mediation. We now also have mediation guides, which are really educative, both for investors and for states and state officials. Reading those guides, you get a good understanding for what mediation is, how it works, and how it can be utilized in ISDS. And the ECT, the Energy Charter Secretariat, has promulgated a guide, and CEDAR has just promulgated a guide, actually, in conjunction with work it did with 16 international law firms to provide guidance as to investor-state mediation as well. Training of mediators, so capacity building, is an essential part of this. You have to have mediators who actually understand mediation in the context of ISDS, and that's very different than commercial mediation. And so with the ECT, CEDAR, and ICSID, there have been courses now run over the last 4 or 5 years, training mediators so that they have the capability of dealing with these very complex types of disputes. The institutional support has been critical here too, and Chin has already referred to UNCITRAL, and UNCITRAL looking at ISDS reform has played a huge role here, and will, I think, continue to play a huge role, as Chin just referred to the next discussion with respect to mediation itself. And I think as UNCITRAL also incorporates mediation, we're going to see that states, because states are critical here, investors are interested in some type of commercial resolution, and that's really what interests them. But states have a lot of other objectives that they have to meet in resolving these disputes. And UNCITRAL being an important element of giving states the credibility and the faith in the utilization of the mediation process, which to many states and state officials is still something that is not fully understood, and so is seen with some suspicion. So having institutions like UNCITRAL behind it plays a very important role. The ECT has played a leading role here as well, because one of the key objections that states have, and Romesh also refers to this in his article, is that there isn't generally a framework within state institutions to allow them to utilize mediation. The mediation process is one that is not very transparent, and states and state officials are often reluctant to engage in mediation for that reason. So states have to create a framework within their state institutions to allow for mediation to take place. And the ECT actually has promulgated back in 2018 a framework for the institutionalization of mediation within the ISDS process, and that is to be commended. And anybody who's interested, go to the ECT website and look for the model protocol for investment disputes, and you will find that it's a very interesting document, and some states have already incorporated that, and that is really, I think, essential. There is already one IS mediation panel that has been created out of the cadre of mediators that have been trained. That was put in place at the ADGM in Abu Dhabi in March of this year. So it's a place that you can go to and find mediators who are trained in ISDS mediation. So that's an important step, and I'm sure there will be many other panels over the next few years that will be established to do that as well. And I've got to commend the Singapore Convention as well. Chin has already talked about it a bit here, but from my perspective as a mediator, it's an extremely powerful tool when talking to parties about the potential use of mediation, because it's something that states are behind. It's a treaty. States have actually consented to become part of it. And by doing that, they recognize mediation as a credible tool. So it gives credibility to the process of mediation, in a way that nothing else really could. And I think from my perspective in IS mediation, the Singapore Convention is extremely important from that perspective, let alone the enforcement of settlements as well. So that's a very powerful, I think, message that has been sent by the Singapore Convention. If I could just go to the next slide quickly. So I'm going to talk very briefly, and I could talk probably for an hour about this, some of the advantages that mediation actually brings to the table here. In investment, in an investment context, very important for states. And this really is, it has to be emphasized to states that embracing mediation actually is a positive signal that they're showing to investors. And in particular, it helps to maintain the investment relationship. Mediation, if used by a state strategically and by implementing it in its grievance process with investors, allows for conflicts or issues that might arise in the life of an investment to be dealt with at an early stage. So it doesn't even get to arbitration or to the stage where there's an ingrained dispute that has to be determined in arbitration. So maintaining a relationship where that relationship, of course, is one that the state and the investor want to maintain, mediation is probably the best tool for resolving any issues. Clearly, arbitration, by the time you get to that and an award, that is not going to be conducive to any long-lasting relationship. The other point made, and this was made by Anna, is that often in arbitration, all the tribunal can do is make a monetary award. But the monetary award isn't often the real issue at the heart of the dispute. And so there are many other matters that are non-monetary that can be addressed in the mediation, in the discussion between the parties through the facilitation of a neutral, that are at the heart of the dispute. They could be tax issues, they could be community issues, they can be environmental issues. All of those can be addressed in a mediated settlement, but they can't be addressed in an award. So the other important aspect here, and if I could just finish with this, is that parties control the mediated outcome. And for a state, this is extremely important because they have an opportunity to mold a settlement agreement with an investor, also if it includes financial compensation, on their terms, on their timetable. The worst thing that can happen to a state is to have a huge award made against it, and that throws their whole budget into disarray. And really, at the end of the day, the state gets no benefit from making that payment because the investment probably has come to an end. So finding a mediated settlement where the parties themselves agree to their terms is a very, very powerful tool. So with that, I'm afraid I've run out of time. There's a lot more that I could have said, but I really appreciate the ability to be able to speak to you here today. Thank you.
Thank you very much, Wolf, and with apologies again to all for the constraints of time that we have. But it does leave us then with a bit of time to ask some questions and to engage with one another. And I encourage people to put their questions in the Q&A section. At the moment, we don't have any pending questions, but that doesn't mean that there are no questions, because I do have a few questions which I think pertain to each of your presentations. I guess first, this one may be directed towards Wolf, and Wolf, what I appreciate about your presentation is that it's a reality check on all of the formal reform that's going on. Rules are great, and optimal rules are great. But unless participants are willing to use those rules, and unless parties, states, and investors are willing to actually enter into mediation, the rules are useless. They may be the best rules ever, but if nobody's using them, they're not doing a lot of good. So figuring out ways to sell the process, to educate users about the process is fascinating to me as a technical matter. How do you do that best? And you touched upon the idea of mediation really as being a form of investment aftercare, as a way of mediating disputes, grievances before they get to a formal level, and as a way of facilitating the perpetuation of the investor-state relationship, keeping the investor in the market. But that then raises the question for me whether these types of provisions are best placed in investment treaties, because investment treaties are very formal, very rights-oriented documents which seem to point one towards an enforcement of rights, even if mediation is also mentioned, and whether they might not be better placed in domestic foreign investment laws or in laws which establish ombudspersons to deal with generalized grievances. So that's one thing to throw out there. The second question, and this is for all of you, is if mediation is a great or is a viable way of addressing the concerns and the disputes that investors might have, and we can find a way for states to see the value of this. Does the mediation process, though, sufficiently address the legitimacy concerns that have been raised about investor-state dispute settlement more generally? Mediation is a generally confidential process between the parties. There is no mandatory mechanism to allow third parties, NGOs, etc., to make submissions, amicus submissions, and there is, concern about transparency, of course. So these things have been an issue for investor-state arbitration. Are they not an issue for mediation? And then finally, because this is the Singapore Convention week, without being churlish, it is worth pointing out that nearly half of the states which have ratified the Singapore Convention at this point have specifically entered reservations which preclude the convention from applying to mediated settlements involving the state. So obviously that will tend to undermine its value to mediation in the context of investor-state relations. So what can we do there to change that percentage and move states towards embracing mediation for their disputes, the disputes to which they're parties? Those are open questions, and whoever would like to take a bite at one or some of them, please jump right in.
Yeah, I mean, maybe Jansen, just addressing the first question you raised. I agree. I think there are probably multiple paths to the use of mediation in investor-state relations. Treaties are one, domestic law is another. I think another important one, and this is where I've seen it being utilized now more frequently, is also in the actual investment agreements between the investor and the state, concession agreements, for example, that build into them actually a mediation as a tool that can be utilized. And so just as in commercial agreements, mediation is built into them, this is very much the same thing. And so I think that also will help for the utilization. I think, as you said, things like ombudsman programs, which are now becoming quite prevalent in states, can also then add to them in domestic legislation the use of some type of a facilitated negotiation or mediation where an issue arises with an investor. And I think these early mechanisms are extremely useful, and I think that will assist in the utilization of mediation.
Thank you. Anna or Chin on the transparency legitimacy point, or Romesh, from your findings?
I can speak briefly to the transparency and legitimacy point. And in this context, it's interesting to note that when we promulgated our first draft and second draft of the mediation rules, our provision on confidentiality of the fact of the mediation itself was actually weighted in the opposite direction than ultimately it is. So our initial proposal was that the fact of the mediation would not be confidential, and at the request of many of our member states, that the balance has shifted in the final version. So now it is confidential unless the parties agree otherwise. So there is a tension there, I guess, between states or requests for transparency to be taken into account, and actually states' own preferences as regards to how much confidentiality should by default exist with respect to mediation. You raised a point regarding participation of third parties in the process, and I think you're probably referencing mechanisms within arbitration where NGOs or other third parties can seek leave to intervene. And it is true that there isn't necessarily a mechanism to allow a third party to interject themselves into a mediation. That said, because of the flexibility of the process, in circumstances where the key disputing parties believe it would be useful to ultimately get to a settled resolution, to take into account the views of a third party. So, for example, in a dispute where there is a specific community that's particularly affected by issues relating to the dispute, there is, of course, that flexibility to have those representatives of those interests actually become parties to the mediation, even if they are not directly the disputing parties. So there is sort of a counterbalance there, I think, on that point.
Well, and Jansen, I guess it leads me to answer the last of your questions about the fact that of the 9 or 10 ratifications so far, almost half of the states have entered reservations. That's the one under Article 8.1, which exempts or excludes mediated settlements involving a government or a government agency. I mean, I can't speak for any of the ratifying countries, obviously. I can only speak from Singapore's perspective, and when we ratified the treaty, we did not enter that reservation. We were one of the earliest ratifiers. As time has gone by, it seems that more states have entered these reservations, and personally, I'd say that this is a little bit of a disappointing development. Having said that, we fully recognize that there is a sovereign prerogative, and it could be reflective of I don't know, a dip toes in water, wait and see kind of a sentiment. I won't say, I'll never say never, because I believe that a reservation entered now can always be withdrawn at a later stage, and I certainly hope that it moves in that direction. I think that one aspect that needs to be addressed would be confidence, right? And it could be that this is a new space, it's a new universe, and that's why there is a bit of hesitance, a bit of I suppose a bit of a wait and see there. Hopefully, as the discussions become more fleshed out, more robust, and more developed on the multilateral fora, such as at in Uncitrol Working Group 3, where we start having draft provisions that can be inserted in treaties, draft guidelines on mediation. There is more predictability, there is more understanding, more familiarity with what creature it is that we're creating and talking about. Future states or future signatories that do ratify the Singapore Convention will have more confidence and will be, I suppose, will be encouraged to not enter the reservation under Article 8.1, and those that have entered such reservations hopefully may be persuaded to actually consider withdrawing the reservation. So I will just leave it at that, and I suppose we'll wait to see how it develops.
Thanks a lot, Chin, and thanks to all of our speakers who have been generous in and allowing us to go over a bit. Romesh, let me give you the last word on any of the questions that I raised, or any points that you'd like to draw out.
Thanks, Jansen. But I think all the speakers covered the points really well. One additional point on the first comment about, how can you actually get ISDS mediation or conciliation sort of make it permeate more. Could you do it through domestic law? I think because I'm sort of, I suppose my work relates to treaties much more. To me, the closer it's connected to the treaty which offers mediation, the explanation of the process, I think that will help, because the investors go to the treaties first, they look at that, and that's what they see. Now, if there's a connection between the treaty, and I think the Energy Charter, initiatives and ICSID initiatives will help with this, but something flowing from the treaty, because a disputing investor goes to the treaty first, looks at the treaty and looks at its options, and somehow to get those options vocalized through the treaty or annexes or even commentaries to the treaty, I think very important. And and it's a bit ironic, but I thought one way of explaining these treaties was really well done by the US government when it was putting forward PPP, and it came up with this very very heavy, sort of very easy to understand text of the TPP, but obviously the US haven't followed up on that. But the actual way that they did it, I thought was quite attractive. So to have that, to have an explanation of the treaty, or in that way, and make it more practical, maybe it draws that connection between the investor and the investor's needs. So again, there are lots of different options, but I think the more the better.
Well, thank you, Romesh. Thank you to all of our speakers. It's been a pleasure to moderate this panel and to learn from all of you. And Romesh, your research and the perspective of all of our commentators. Romesh, would you like to sign us off as the convener? If not, otherwise, thank you all very much for joining in our audience. We hope that you've found this webinar useful, and hope that you will tune into another webinar from the Center for International Law in the future. And with that, thank you and goodbye.
Goodbye.
Thank you. Bye.